welcome back to another episode. My name is Joshua Vigo-Fas, your probate realtor here in Los Angeles, California. Today we're doing an episode a little bit different. We're doing a Q&A with attorney Daniel Van Slyke and Miss Elvia Sukup. And the goal for today is to just do a question and answer on some common topics that people going through the probate and trust administration process. Thank you both for being here. It's a pleasure to have you. So I guess we'll start with you, sir. I have a couple of questions for you that I'd like to ask you, if you're ready.
I'm ready, yes. And thank you very much for the invitation to be here with you today.
Of course. So let's start with just tell us about yourself and how you became a lawyer, and specifically how you got into the trust and estates world.
Very good. Well, I became a lawyer because I really wanted to help people in the practical world. I had been a teacher before that. And I figured, well, academics make a contribution to society, but I'd like to make a different type of contribution. And I went into law. And my first job, I wound up doing litigation. And I had all the cases that dealt with people who were deceased or incapacitated. And I developed an expertise in probate matters. So those are the court proceedings that take place when somebody's dead or incapacitated. Mm-hmm. And I really learned as I was doing that, I had a great rapport with folks who were going through this process, this grieving process, and were very, it was very stressful for them. And part of the stress was that they didn't know what was happening. Mm-hmm. And they just needed somebody to listen to them and explain to them the process. And as I was doing that and really learning the needs of these families, I realized that I could serve people much better by helping them to avoid litigation in the first place, to try to avoid those probate proceedings. And that's when I made a shift to really focus more of my practice on estate planning. Mm-hmm. The goal there is to make sure that everything goes smoothly when somebody becomes incapacitated or dies, try to avoid fights among family members, and try to make sure that the clients have peace about how things are arranged and about what's going to happen when something happens to them. Mm-hmm.
So in litigation, you were primarily dealing with families that were fighting amongst each other, that were contesting a will, or they just they had siblings that hated each other's guts, that always grew up fighting, all the above?
All the above. Most of it was just bad planning, because that's when it wound up in court. Somebody didn't plan. A lot of these cases, there might have been a will, but it wasn't a very good one. Yeah. I've seen wills that put more emphasis on the type of beer to be served at the funeral than they do on actually disposing real property, right? So you would think that the real property would be the issue. Yeah. I had cases where people, murder, suicides, crazy things, a lot of sad cases actually, but it was quite an experience. I handled dozens, actually hundreds of matters. And Texas has this doctrine where you can become a common law spouse. And I did a lot of that practice in Texas. So I'm licensed in Texas and California, but I saw many occasions on which a caregiver or somebody like that, after the old man died, appeared and said, I was his wife, I'm his common law spouse. Yeah. And that throws a wrench into the planning and can alienate the family members and cause a lot of delay and fighting.
Why do you think that not enough people have their estate plan completed? And I'll just follow up with this. I live in a community of 150 homes, right? And being in real estate, I have this mindset of I've gone through every single street. I've looked at all the houses. Oh, who owns this house? Who owns this house? And I probably would say that probably not even 5% of the people that live in my neighborhood even have an estate plan. Right. And so me as a real estate professional and doing a lot of probates and seeing celebrities that end up in court, right, and getting probated, why don't more people know about an estate plan? Are they not thinking about dying? I've always wondered, is it a cultural thing? Do people not want to talk? You know what I mean? Why do you think that it is?
Yeah, and you're right about even celebrities not having estate plans. Michael Jackson's a great example. His estate became a mess of people fighting and litigating after he passed. I think part of it is some people just don't think of it. They're busy living day to day, and until some life event happens, they don't really take that step. Oftentimes, a life event for younger people will be having a child. So if they have a child, they're like, "Oh wow, we have to take care of this child." There's a new sense of responsibility, a new sense of planning for the future.
Yeah.
But even that's not a trigger for many people. And I think part of it is some people just are afraid to talk about death and dying and incapacity. They don't really want to admit that that's going to be an issue for them. And that causes delay. And that's where I really emphasize with my clients kind of the planning and the piece that it brings to not put it off and then have these worries in the back of your mind,
Right.
but actually to take steps to ensure that what you want to happen is what happens when something, when you either become incapacitated or
Right.
die. Because you can have a lot of control over that,
Yeah.
over your assets, your care if you should become incapacitated, if you take the steps to put those planning documents in place. But if you don't, then nobody knows what you want. People might
Right.
fight over it. Things that you would never want happening could take place.
Yeah. I know for me, it jump-started me when I had my daughter, almost 4 years in 2021. As soon as that happened, I started thinking about something happens to me and my wife, who's the guardian, right? And so I know that's one of the pillars of having a living trust is guardianship, right? So we wanted to make sure something happens to me and mom, my parents are gonna fly from the East Coast, my sister-in-law can grab her from school and kind of, just watch her until my parents get here and they become the guardians. So I that was a big jump start for me, is having our daughter. What are kind of the key pillars of a living trust, right? So I know, a power of attorney, advanced healthcare directive, like, is it enough to just have a living trust, or do you need to do other things in order for it to be considered valid? Or
Yes. Is it enough to have a trust? Not really, because you have some assets that won't be controlled by the trust. It's kind of like those old commercials, this is part of a complete nutritious breakfast, right? And then you see the orange juice and the eggs and everything that's with the sugary cereal, right?
Yeah.
So, I mean, you can think of the trust as being the center of your estate plan, but it's not sufficient, because some things are not controlled by your trust, and they wouldn't be controlled by probate either. We call them extra probate assets. There are things like life insurance, things like retirement accounts. If those things are not in the trust, or if they're not funded to the trust, then the trust doesn't control them. So there are other documents that you really need to have a complete estate plan, and that includes, for example, if you have minor children, nominations for the guardians. Or conservators. If you, for your assets while you're still alive, if you go through a period of incapacity, you're going to want powers of attorney. For asset management, you're also going to need healthcare powers of attorney or healthcare directives, and things that appoint people to be able to make decisions for your healthcare in the event you're unable to do so. And also documents where you can determine how it is that your decisions will be made for your care. And you can kind of give some instructions in advance. And then finally, there's a will. So we call it a pour over will when you have a trust, because sometimes you have an asset that didn't get funded to the trust. And if it's not in the trust doesn't help with it. So a pour over will, basically it pours that asset into the trust. And
got it.
a common example is, that I like to use, maybe it's not that common, winning the lottery.
Okay.
Let's say you win the lottery and you die of a heart attack. Well, that's great. You won the lottery, and that's a lot of money into your estate, but it didn't get put in your trust. So the pour over will pours that money into your trust so that then it can go the way that you want it to go.
Got it. Is that how you fund the trust, is through a pour over will, or is there other ways? Like if you have like I have a 401k, if I didn't put my 401k into the Fascavada family trust, right? Would the trust dictate that it's going to be in the trust regardless of whether I changed it?
I am so happy you asked that question. And the reason is because funding is a key place where a lot of people's estate planning kind of falls by the wayside,
Okay.
especially if they don't have an attorney advising them and they, prepared the trust on a document creation platform or something like that. So funding the trust is absolutely key. And without any funding, you have what's called an empty trust or an unfunded trust.
Okay.
It doesn't do anything for you, nothing at all. So how do you fund things to your trust? Well, if you have a home or a real property, then what you do is you deed it into the trust.
Mm-hmm.
So you go from owning it in your own name to owning it in your name as trustee of your trust. That's all it takes, but that title change makes sure that your house avoids probate, makes everything go a lot smoother when something happens to you.
Got it.
So 401ks can't be owned by a trust. So you can name a trust as a beneficiary, but you really have to plan that carefully because that can have bad tax consequences.
Got it.
So 401ks are going to go by the beneficiary designation that is on file with the company. So when I'm, with your brokerage firm or wherever the 401k is held, say it's Fidelity or Vanguard or something.
Mm-hmm.
So when I'm doing an estate plan with somebody, I walk through all their assets to make sure everything is where it should be, to be sure that their wishes are met.
Got it.
When they're gone or again, when they're incapacitated. Bank accounts, same thing as a house. You change the way you own the bank account from your name to your name as trustee of your trust.
Got it.
So all this, the funding is extremely important. And if you don't do the funding properly, your estate's still going to wind up in court.
Got it. If it exceeds the threshold, correct? So basically, if I have a bank account that's got 125,000, it doesn't have the trust as beneficiary and it doesn't have the trust as the owner, that would be subject to probate, even though I have a trust, or is that more of a Hegstead petition where you're asking the court, hey, the house is in the trust and everything else, there's an intention to put it in the trust, except this bank account, he was a goonie and didn't put it in the trust. Can we request to put this as part of the trust asset?
Right. Very good question. And, just for the audience, a Hegstead petition it's a probate court petition, right? Where you come to the court and you say this asset, usually it's a pretty valuable asset, like a piece of real property or something like that, or maybe a business interest. We have evidence that, dad or mom or whoever has passed away wanted it in the trust, but never got around to putting it in the trust. And so we're asking the court to put it in the trust.
Right.
That's a Hegstead petition. Can be smooth if everybody agrees, but can become a messy, contested probate issue if you have people who don't agree with it. And so that's one way to deal with something that wasn't in a trust. Now, the other thing you mentioned is called a small estate affidavit. Mm-hmm. In California, that's if your estate is under $184,000. Mm-hmm. And in theory, it's an affidavit that meets certain requirements. So it's just a document that can be signed. And then some smaller, bank accounts, things like that are under that threshold can be given to the beneficiaries just on the basis of that small estate affidavit.
Got it. What are some common mistakes that you see with the estate planning aspect portion? And then a separate question is, what are some common mistakes that you see with a probate administration?
Yes. Well, estate planning, one thing is putting it off and never doing it. I mean, that's the biggest mistake that most people make is just not having a plan.
Yep.
If you don't have a plan, the state has one for you. It's called intestacy, and it may not be something that you like or what you would wish, especially if you have a mixed family. And then it can cause a lot of difficulties down the road. So that's one thing is just not planning. Another thing is, as we mentioned, having a trust and not funding it, or just getting the trust, putting it on a shelf and forgetting about it. And then a decade later, 2 decades later, your state changes, law changes, you never updated it. So that happens a lot. And then as far as when estate administration comes in after somebody passes, one of the biggest mistakes I see is just ignoring what needs to be done. So people will, for example, a lot of older trusts for married couples have these splits. They have these A-B splits, which means when the first spouse dies, there's we call it the alive spouses portion and the buried spouses portion. They split into different trusts. And assets should be allocated that way. But I have met so many clients who never did that. So, the first spouse died, they never attended to the split, they never filed required tax forms, things like that. They just, and you understand people are grieving. They may not be the surviving spouse might not be the one that handled finances. It happens a lot. But then that can cause a big mess down the line, because then you have to do a forensic accounting to see what the properties were worth, when the first spouse died. So ignoring it is a big problem. So when somebody dies, you really should, even if you have a trust, especially if you have a trust, you want to contact a trust administration attorney and make sure that things are done right. Yeah. It's going to be a lot less expensive than a probate proceeding,
right?
Most likely, unless you have a giant estate, in which case it's worth every penny. But it's worth it. And I think, when we get back to the reason why some people don't plan or don't, properly take the correct steps after somebody dies, a lot of it's because people are afraid of lawyers. I think with my clients, a number of them, I'm the first lawyer they've ever dealt with. I guess they're lucky like that. So, and they're afraid of lawyers, and it's 99% of lawyers give the rest of us a bad name. Oh, that was a joke. Anyway, so I try to really put them at ease and make them feel, like they understand the process. And because I do teach it to them, that's my background as a teacher. I love explaining things and answering questions. Yeah. So to really put them at ease, and then to realize that not all lawyers are scary.
Yep.
So that's a big thing. And then the estate planning attorney will become kind of like the go-to lawyer, the lawyer they know. So any other legal problem they ever have, they come and they ask me.
The family lawyer.
Yeah, where do I go for this or that? And that's one reason I love to network and meet folks like you, because then I can say, well, I know this great guy who can help you with that real estate issue. I know this great gal who can help you with your banking needs. So that becomes a big part of my job.
Yeah. So you mentioned there being a threshold, right, for probate, which is $184,000. Is that what you mentioned? I understand that's now changing. Coming in April of 2025 through AB 2016, which just passed, I think, like 2 months ago. So I guess if you want to explain what AB 2016 is and how you think that will kind of change the climate of the trust and estate world.
Okay, so this is very California specific.
Yes.
AB is, it's a assembly bill.
Yep.
2016 doesn't have anything to do with the year. And that $184,000 that we mentioned is part of it. That is for the small estate affidavit. And that number, by the way, changes. It's adjusted for inflation. Right. That's what it is in 2024 as we're speaking, but that could be different next year. Now, the other part of AB 2016 is this section that deals with real estate. The $750,000 number that you hear associated with it says that you can have a special probate proceeding to deal with a property if it is worth $750,000 or less. It's still a probate proceeding. I think a lot of people, if they think that this is going to make the small estate affidavit easier, it's not. This is a separate thing. But it's supposed to be an expedited probate proceeding to help you deal with a house if its value is $750,000 or less. Right. You still need an attorney to file the petition. I don't think too many people are going to be able to do this on their own. Yeah. You're still going to need in California what they call a probate referee, which is somebody who values the property. You're still going to need a real estate agent to sell the property. So I don't think this really changes the need for estate planning because that procedure for dealing with the property is just another probate proceeding. And somebody could come in and contest, and it could become a mess and take a long time, like any other probate proceeding. That's one of the reasons you want to try to stay out of court.
Right.
I do everything I can to keep my clients out of court.
Of course.
Everything I can.
Yeah.
Because that's what serves them best, and that's what's least stressful, that's what's least expensive. So in my mind, that's not a huge leap forward in estate planning. It's not going to reduce the need for a good estate plan.
Right. Probate sucks. I think a lot of people would agree. the 750,000 is basically saying anything below 750 is not going to be subject to probate anymore, correct?
If you have a real property
If you have a real
that's your
property.
home
Right.
and it's worth under that, then it is subject to probate. I mean, that's still a probate proceeding. It's just an expedited probate
Got
proceeding.
it.
Yeah.
So what about, I think one of the good things, if you can say that, about probate is that it's such a court supervised process, right? Everything is, goes through the court. You have to give ample notice. You have to notify all of the beneficiaries. Is there a concern that with AB 2016, a lot of that notice period that you normally give out to family members might not be happening in such a supervised process like it is with probate?
Yeah, I've read the bill. It still has notice provisions.
It does?
Yeah, so you still
Okay.
have to notify. That's why I think a lot of people that get excited about this probably don't understand all the implications of it. It's
Got it.
not that big a step forward.
Got it.
It really, I don't think it doesn't eliminate the need for good planning, because you still have to, and that's the problem, is when you start notifying beneficiaries, then you're opening the door to somebody coming in and contesting.
Right.
And if they contest it, then that expedited procedure, which promised to take a shorter period than a regular probate proceeding, can now be dragged out for years.
Got it.
I guess in principle, maybe if it's $750,000 or less, that's not a lot of money for property in California. Maybe that will lessen the possibility of people fighting over it. But, fights in the probate courts are not necessarily driven by reason and economics. Sometimes they're driven by emotion.
Yeah.
It's like, you got that red wagon when we were 12 and I never did.
Yeah.
It's not fair.
Yeah. Yeah. For some reason, I thought that the notice, that was going to be a big change, right, with this bill, where it would lead to kind of more litigation or more fraud, or more family members, the house being sold without one of the beneficiaries being notified, right? And so they would find out a year later, and then they'd come back, hire an attorney, and then all hell would ensue with this litigation. So do you think that will happen? Do you think there's still, I mean, you can sue anybody for anything here in California. Do you think that cracks the door open a little bit more for that to happen?
It's certainly possible, and I've seen it before. It's like an obituary. When you do as much probate litigation as I've done, and you read an obituary, you always realize that somebody wrote the obituary. Mm-hmm. And whoever wrote the obituary is doing it from their perspective, right? Mm-hmm. So if I'm like the child of the first marriage and I write the obituary, I might omit all the children from the second marriage and not even mention them, not even mention the second wife or something like that, or vice versa, right? Yeah. So that kind of thing can happen in the probate court. And I've seen it. I've seen people get probate orders from a court where they left out heirs. And I believe it was intentional. I mean, it could have been accidental, but either way, there were heirs left out, and that just opens the door to further litigation and further trouble down the end.
All right, sir. Well, I think I am all out of questions to ask you. For the audience, is there anything that I didn't ask or I didn't cover that you would like to add, or anything that you would like to ask me? The floor is yours.
Well, thank you again for inviting me. It's been a pleasure chatting with you. And I think I just want to add, don't be afraid to reach out to an estate planning attorney if you're at all hesitating. We don't bite. And you can find me at iplanlaw.com. I have a YouTube channel as well as a website, and that's www.planlaw.com.
Awesome. Thank you so much.
Thank you.
All right, Miss Elvia, we're going to segue to you.
Hello.
How you doing?
I'm doing good. How you doing?
Good, good. So you are a banker with Cal Private Banking, correct?
Cal Private Bank.
Cal Private Bank.
I am a banker, private banker. Happy to be here.
Thank you. So tell us kind of how you started. Have you always been a banker? Walk us through your career, I guess, so to speak.
My journey.
Your journey.
Okay. I started in banking early on while I was still in high school.
Okay.
I always knew that I wanted to do something meaningful in life. I like to help people and make a difference. So going into banking allowed me to, learn what I needed to learn to be an advisor to clients and help them with their finances. So while still in high school, I enrolled, actually, I should say. I became a member of the Academy of Finance. And that program allowed me to learn all the facets of customer service, finance, relationship management. I became a teller right after high school with all the skills that I got in that program. I did become an actual teller, then went on to college. While I was getting my degree in college, I was working as a teller. Then got out of college, stayed in banking, which is important. I didn't deviate. I continue in banking. All these years of experience, I feel like the culmination of these years of experience got me to Cal Private Bank.
Got it. Awesome.
At Cal Private Bank, I assist families going through the devastating loss of a loved one, and just being able to be there for them makes me, feel like I'm doing something good for them.
Yeah. Is that your main clientele? Like, do you have like other kind of clients, like your walk-in kind of, like, do you have clients that just walk in, wanting to deposit a $50,000 check, or is it mainly like working with attorneys and estates and families that are either through a probate or a trust?
My role at Cal Private Bank is to build relationships with professionals like yourself.
Okay.
So I surround myself by trust and estate attorneys, realtors that understand probate, appraisers, anyone that touches CPAs, anyone that is part of the financial planning. That again, that's what I do. That's mainly my focus, working with families that are going through the loss of a loved one, being a resource for them, understanding what they are going through, and being able to accommodate to their needs. And it's just something that I honestly enjoy. It's a reward for me to be able to assist and make things happen for these families.
Got it.
Yeah.
Did you know that, was that kind of the next step from, starting as a teller? Like, is that did you know that's kind of what you wanted to do? Did you know you wanted to stay within banking? What, I guess, are there different branches within the banking industry that you could have gone into? Does that make sense?
It makes sense. I did envision myself doing something bigger in banking, because in banking you have the opportunity to go sideways, escalate, do different things. Being a teller is the foundation, right? You learn how to talk to clients, how to manage their cash, you understand their needs, because you get people coming in asking questions, finding solutions for them is what you learn first when you're a teller. So I knew that I wanted to be more involved in the process. As I got involved in different roles in banking, I started learning about, working with small businesses. And there's business succession. So when the business owner passes, okay, what happens to the business? Is it an step? If they die and they are the only providers, what's going to happen to the family? Will the family be able to survive? So all these questions started coming in my mind, and I wanted to be part of something bigger, and estate planning was that.
Got it.
So I started getting, involved in reviewing financials, understanding the operations of the business, and how that leads to, the family well-being, having all these assets and making sure that they are protected at the end of the day.
Right.
There are financial advisors at the bank. I learn from them. I'm not an investor or licensed to talk investments, but I learn also how can families invest their funds and, just allocate the funds properly so they grow within the specific time for the specific goal. Yeah.
Got it. Let's say you know, a daughter is coming to you, right? Single, you know, only daughter, mom passed away, no trust, going through probate. What's the next step? What kind of conversation do you have with her, right? Because there's two kind of avenues, right? You have your probate estate account, right, and then you have your trust account, right? Are those two separate things? You know, do you need different documents to open those? I know the answer to this, but you know, want to.
Of course. Well, when someone is establishing a trust account, that means there is some financial planning in place.
Mm-hmm.
So mom and dad met with a trust and estate attorney, so they want to make sure that they pour in all the assets they are pouring in, the bank accounts they are going to be vested under the trust to protect those assets. So that's an indication that there is financial planning. A probate account, an estate account, means that there was no financial planning in place. So now things have assets need to be collected to later on distribute them to the beneficiaries by court mandate. So when this young lady comes to me and she has a trust documents, that means, yeah, I'm gonna be able to set up this account for them. Mom and dad passed, I need to know if the actual account was placed under the name of the trust. If not, most likely there will be a probate proceeding.
Got it.
I could either refer her to a trust and estate attorney, or she might be already in conversations with a trust and estate attorney.
Got it.
So it's a matter of finding out what she's looking to do at the bank.
So for a probate, what are the documents that you ask for? Right, you find out, hey, you got to go through probate, go talk to an attorney. When you have this, then we can open the bank account.
Banks typically require the certified letters of administration or letters testamentary. They also need the tax ID number, which is the EIN for the estate. The death certificate, that's very important. We need to confirm that the owner of the funds is dead. And then we need to identify the person that is going to be managing the account, executor or administrator.
Got it. You need to confirm that they live in the state. What do you typically look for? Do they have to have good credit? Like, what do you need to verify?
Well, we need to know that they are who they say they are.
Got it. So some form of ID. Got it.
Driver license.
Got it.
We create a profile for them.
Okay.
So yeah, all that information is vetted.
Got it. And that it matches what's on the letters of administration or the testamentary letters. What about for a trust account, right? So you have, obviously there's estate planning done, someone planned ahead. What do you need in that aspect when that happens?
For a trust account, we ask for specific pages of the trust.
Okay.
Just to validate who created the trust, who's managing the trust as a trustee.
Okay.
The EIN, which is a tax ID for the trust. If someone passed away, we need the death certificate. And then we need to, again, identify the trustee who's managing.
So it's like four things typically that you ask for.
Yeah, but again, it depends on the situation. That's when we have a one-on-one with these individuals and understand what's going on.
Got it. So one of the common things that I've heard, right, or I guess objections, right, from clients that we deal with, a lot of times I work with clients that live out of state, right? Not every client lives in California. Mom or dad had a property here in whatever, Sherman Oaks, but they live in Arkansas, right? And so one of the objections I get is, oh, well, I can just go down to, you know, the Truist Bank, right, which is a local bank in the South or whatever, and I can open an estate account there. I don't need to open an account in California. Have you heard that objection, or you know, people say that?
We do, but if the assets are in California, if the decedent had their real estate or they lived in California, then the probate proceeds should be in California. That includes the bank account. So we do work with out-of-state administrators, executors. We connect with them and again, just work remotely, fully remotely.
Yeah.
And that's not an objection really.
Okay.
But it could be something that we need to just navigate through and make it happen for them.
Are there any documents that clients need to have notarized if they live out of state?
No.
Like to verify identity?
No.
Okay.
They need to provide us with their driver license
Okay.
And their personal information that includes their social. So again, banks have ways to verify and vet all this information.
Okay. Do you think another thing that I've heard is that clients typically want to open an estate account where the decedent had their money already parked? I hear this a lot, right? So, you know, Jane Smith is the decedent. She had whatever, 100 grand in Bank of America. And because they think it's easier, right, because you just keep everything there, they want to open the estate account there, right? And so I've witnessed that firsthand, right? Hearing the client going in the branch and then getting, you know, the legal department, so, you know, involved in the escalation levels. Do you typically, what do you typically tell, I guess, people when they tell you that?
Well, obviously, it's whatever is works for them and whatever makes them more comfortable. But from a point of view of someone that understands how probate could go, someone who's been in banking for 20 plus years, I can tell you that accidentally mingling of funds could happen. When people don't have the sophistication enough to maintain all the assets separated. So the safest thing to do is to go to another bank. Keep things separate, set up your probate or trust account at a bank that you don't have your personal account or your business account at, because you want to be able to have a good accounting for that account, and working with a banker that understands the process and will make sure to keep good financial records for you to present to court. It's very important.
Have you seen people that do that through commingling of funds? Like, do they take money out of mom or dad's account and then, like, do they write their check, you know, themselves a check, or, you know, Zelle themselves whatever, you know, $500? Is that?
I haven't seen that happen.
Okay.
Because we have very good controls at Cal Private Bank. We don't allow that to happen.
Okay.
So when we're assisting clients, it's of most importance for them to understand that we will be working very closely with them to make sure that everything is going to be processed by what the court will like to see.
Got it.
Keep things very clear for the courts. If they do it at their bank where they decided to go and work with another bank where they have their personal account and they're doing that, yeah, that's a problem.
Got it.
I haven't seen that.
So do you have some level of monitoring in terms of the estate account? Does it flag you when money gets taken out, when a transaction goes through? How does that work?
We have systems in place.
Okay.
I obviously cannot disclose that, but we do make sure that we keep an eye on the accounts, especially if the account requires 2 signatures, or if there is a specific reason to keep the account flagged and monitored. We have systems in place.
Got it. Okay, so let's say mom had a house, right? We still have the surviving daughter, and the house is in Sherman Oaks. She sells it for whatever, $1 million, and after closing costs, whatever, she walks away with $950,000, right? The funds, typically you would have them wired into the estate account, wired or a check, right, for the estate of Jane Smith.
Yes.
And then typically, what's that process like? Do you confirm the funds go in? How does kind of the distribution, right? how did both of you work when it comes to the distribution aspect, right? Because then at that point, you guys are kind of working together. I make sure I sell the house, and on the escrow instructions, right, on the instructions for proceeds, the funds go into the estate account. But then what happens after that in order to distribute kind of the estate?
So your question is, we receive the funds
Right.
from the sale of the house.
Yeah.
So the funds are going to be parked at the bank, and we'll have to wait for the court to approve distribution of funds.
Got it.
For that to happen, there has to be a hearing, there has to
Right.
be accounting done. It's several steps that need to take place. We get notified typically by the attorney that is
Okay.
working the case.
Got it.
The attorney on record will notify the client, the banker, and anyone that needs to have a notification of the funds being ready for disbursement.
Mm-hmm.
At that point, yeah, I'll work closely with the attorney if the attorney is part of the process, because they're not always part of the process. They introduce the client, and then we just continue working with the client. If the attorney is part of the process through a joint control agreement,
Mm-hmm.
or they just want to be notified of every step of the way, we do that. We keep the attorney involved in the process and update it, so they will know when and how we're going to be the distribution once they provide us a copy of the court disposition for that.
Okay. Do you oversee the distribution when it goes out to any beneficiaries?
We do.
Okay.
Yeah, we make sure again that we follow everything to the letter. So the court document is going to indicate who gets what, how much.
Right.
We normally communicate with the beneficiaries directly if that's something that the executor or administrator is okay with. So
Yeah.
we can make those delivery of funds arrangements.
Got it.
And that court order is necessary, just to be clear, only when
Yes.
there's a probate proceeding, right?
Yes.
I mean, for a trust,
Yeah,
you
for a
wouldn't
trust
need
is-
a court order.
It's different, but we're talking probate right
Yeah.
now.
Yes.
All right, Elvia. So, what happens? Because I hear this a lot. The big banks, right? And this is one of the things that I love about Cal Private Bank, is the excess of the $250,000 and the FDIC insurance. So, can you go a little bit? Yeah, elaborate.
I'll elaborate. So the FDIC insurance, the standard FDIC insurance is $250,000 per tax ID number per financial institution.
Mm-hmm.
So when the net assets, the net value of an estate exceeds $250,000, the administrator or executor have the fiduciary obligation of making sure those funds are fully insured under the FDIC. We understand that that's a requirement of banks. I mean, for banks, the courts require that banks are mindful of that and, provide full insurance to their clients. So we have a program that allow us to do just that. Cal Private Bank is a member of a special network that provides FDIC insurance coverage to clients up to $225 million per
Wow.
tax ID number.
Wow. So let's say for the house in Sherman Oaks, the house is free and clear. Mom lived in there for 45 years, and you walk away with the same $950,000. If you go to B of A, Chase, Wells Fargo, any one of these big places, they've got a cap on $250,000 FDIC, right? So out of that 950, only 250 is going to be insured, right? So that essentially leaves 700 grand that's uninsured, right? So if something happens, with 2008 happens all over again.
Again, we don't let that happen when we are assisting clients
Yeah.
that are going through probate. We automatically offer the expanded FDIC insurance through this multi-million-dollar program that we have. The way we do it, we collaborate with other banks that are part of the same special network that we are. So we divide up the funds. The first amount under $250,000 stays with Cal Private Bank, and the rest goes into the special program that will split up the funds. As many banks as needed, the participating banks that are part of this program, we will place the funds. So if you have 750 additional, then we're going to be working with 4 other banks, not 3, but 4, because we need to stay under 250. So we'll do 240, 240, 240, and then whatever small amount is left goes into a 4 bank.
Got it. And are those still accessible by the administrator, the executor, by you? Do they still have access to that account?
The funds are fully available and fully liquid. So when there is a need to access those funds, we will pull those funds out of the special program and apply those funds back to the Cal Private Bank account. So they could be accessed at any time.
Got it. Does that type of account have a special name?
It does, but I'd rather not.
Okay. Just curious.
No problem.
Okay, Elvia, so we've talked about what an estate account is, the documents that are needed for both an estate account and a trust account. You've established that you don't need to live in the same state as the decedent in order to open the estate account, that you can live anywhere in the country. We've talked about everything pertaining to an estate account and everything that you did, including your background. My last question is, what tip, if there's a couple things that you can say, what tip would you provide to not only clients, potential clients that are watching this video, people that, live in Massachusetts, that have a mom or dad or family member that just passed away here and want to learn about what an estate account is and how that works? So what tip would you provide to those and those people, and then what tip would you provide also to any attorneys, trust and estate attorneys like Dan, that are watching this and want to learn more information about setting up an estate account and how that works?
Well, in general, I will cover the families and the attorneys. My tip will be to surround yourself by the right team of professionals that will help you with the probate process. As we know, probate is a very devastating process to go through. Losing a loved one is a hard experience for anyone. So to help you through this, it's a great idea to just, find a great attorney that will know probate, a realtor that also understands the process of probate, a banker that will help you navigate through all this. The bank has to be a bank that accommodates this type of accounts and understands the process. It's not just the banker itself, it's the entire team behind the banker that will make the difference. So having that, it's very essential to be able to go through this process and feel good about the outcome and know that you'll have support and resources along the way.
Yep, absolutely. That's the whole purpose of doing this, why I wanted to do this, because for anybody that watches, it takes a team, right? It takes an attorney to kick off the process. If there's real property involved, it takes a real estate professional. When you sell the house, you got to put the funds into an estate account. It takes a banker. And then the only person that probably I'm not missing is a CPA, right, to do final taxes.
CPAs are really important too.
Yeah.
They need to do the final, accounting for courts to approve distribution of funds.
Absolutely.
So without their work, bankers can do the distribution of funds.
Yeah, and I often get clients that, after I sell the house, they're like, hey, my CPA wants to know what the value of the house is based on date of death, what you think it was worth in 2021 or something like that, right? So I wanted to shoot this video because it takes a team, right? It takes a team of experienced professionals, because this is a dragged out, specifically probate, right? Trust is much shorter, right, in comparison to probate, but probate, you're easily 9 to 12 months that you're going through a court system, right? That is very supervised, where everything has to be done correctly. every form you got to do it correctly, or otherwise it's, you know, fix it, send it back, right? So I wanted people to that are watching this to have an idea of like, hey, this is what you do first. This is a good person, right, that you can contact, right? You need to file a petition with LA Court, other counties, call Dan, right? You got a real property you got to sell, call Josh, right? Because I know the probate process. You got funds that need to be put into an estate account, call Elvia, right? So that's the whole purpose of this video. So I'm glad that you touched on that tip because that's really important.
Thank you,
Yeah.
Josh. Thank you for having me.
You're welcome.
Thank you, Dan, for being here.
Of course.
It's a pleasure again working with these families and helping through the process. It's just very rewarding. I'm sure it's rewarding for all of us.
Yes.
Because we're making a difference for the outcome that they will very much appreciate.
Absolutely. So if anybody wants to get a hold of you, what is the best way to reach you?
Absolutely. You can always email me at esoukup, ESOUKUP, at calprivate.bank. I guess my email address is going to be shown on the video as well.
Okay. All right. Well, that concludes our video. Thank you so much for watching. Dan and Elvia, thank you so much for your time. It was a pleasure having you here. Thank you for sharing your experiences, you know, how you kind of started in this business and what your role entails, and going really in depth, because I think that's really important for families to hear. So thank you for being here and for your time. I know that you guys have a busy schedule, so thank you for joining us.
Thank you.
For anyone watching, if you want to reach out to me, you can email me at info@joshvrealty.com. We'll also put my telephone number on the video as well. And that's it. Thank you all for watching.